you need to establish who owns what in the property. And the way you do that is go to the land registry and download the office copy entries of the registers held by the land registry. There is a separate video explaining how this is done. When you get the office copy entries, you'll see that it's either in 2 or 3 parts. The first part is the property register, which gives the address of the property and sets out the rights it has over other people's property. The second part is the proprietorship register that sets out who owns the property, who is the registered proprietor. And the third is the charges register, which sets out details of who's got an interest in the property by mortgage or if they have rights over the land. Now, what you're interested in as the executor or administrator is to find out in what capacity and who owns the land. So you look in the proprietorship register and it will either be in 1 name or 2. It can only be in a maximum of 4, but that's a different subject altogether. I'm assuming that this is a husband and wife, and the property will either be in the name of the deceased alone, in the deceased and the surviving spouse, or just in the spouse's name. If it's in the name of the deceased alone, then obviously only his name will appear in the proprietorship register. If it is in the surviving spouse's name only, then it never formed part of the deceased's estate, and so you can ignore the value of the property for the purposes of the probate forms. If it is in joint names, then both names will appear, and what you're looking for is to find out whether they are holding the land as joint tenants or as tenants in common. If they hold as joint tenants, then that means that the jus acquescendi, or right of survivorship, takes effect, and so the legal estate automatically passes to the surviving spouse. If, however, they are tenants in common, then the deceased's share does not automatically pass to the survivor, but has to be assented or transferred into the name of the survivor, if that is what it says in the will. Now, unfortunately, the land registry in the proprietorship register don't actually go out and say they hold as joint tenants or they hold as tenants in common. You have to understand how to read what is in the proprietorship register. If it says nothing, then they are joint tenants and the legal estate passes automatically. If, however, the land registry has added words along the lines of no disposition of a legal estate shall take place by a sole proprietor without the order of the court, then that is a restriction that is put on as a result of the parties deciding that they are in fact tenants in common. And if that is the case, you need to fill in a different form for the land registry further down the line. But that is dealt with in a separate video.
not say